All right, everyone, you may be seated. And if you could restate your name for the record, please. Restate your name.
Brad Armstrong.
All right, you're still under oath. All right, ladies and gentlemen, we do have a second court reporter in training who's sitting there. So again, the official record is with Cindy, the court reporter, and she's in training. All right, stated still your witness and you're still under oath. You may proceed.
Thank you, Judge. All right, so to keep going from yesterday, Detective, did you receive video from Albert Perkins regarding the crash?
I'm sorry, who?
From an Albert Perkins, did you receive video of the collision?
So from the, there's a bar correct directly behind it. Yes.
Yeah, that's correct. Did you receive video from that collision?
Yes, I
From
did.
that bar? Okay. First of the record, be playing state exhibit number 2. Detective, do you have a view of the video up there?
I do.
Okay. Go to tools, effects, video effects, geometry, interactive. I'm gonna pause it right here. Detective, are you familiar with the Texas Transportation Code?
Yes, I am.
Are you familiar with the duty of a driver is under the Texas Transportation Code when a light turns yellow?
Yes, they're supposed to slow down.
They're supposed to slow down? Okay. Let me actually rewind that a little bit. So. So Detective, based on this video, Unit 2 is parked here, right?
Yes, right behind that sign.
And this vehicle over here, is this Unit 1?
Yes, that'll be unit 1.
Okay. Pause it there. Was the light yellow in the video that we just saw?
It was, and now it's red. It changed to red.
Does it appear that Unit 1 was slowing down while the light was yellow?
I'm gonna object, cause for speculation.
Sustain.
What appeared to be the behavior of Unit 1 while, from your perception, what was the behavior? Judge, he's allowed to,
Well, here's the thing. I need to hear the question
of course.
and then I'll hear the objection. And then I'll rule on the objection.
Okay. What was the behavior of Unit 1 in the video here? Was he slowing down during the red or during the yellow?
I'm gonna object again, Judge. This is the same question, calls for speculation.
All right. Response to speculation.
Judge, I'm asking him what the behavior of this vehicle is based on his perception of the evidence in front of him.
Right, that objection will be sustained.
Okay. What is the behavior of the vehicles in this video?
I'm gonna object, cause for speculation.
Sustained.
What do you observe the vehicles to be doing in this video?
So what I see is the unit 2 at the light, waiting for a green light. I see the other vehicles approaching. I see there's one light that maintains and holds speed. The other two behind it appear to be slowing down.
I'm just gonna object to any appearing to be slowing down or the speed of any vehicles, as that is speculation. You cannot tell the speed of any vehicles in this video.
Sustained.
What do you observe about the other vehicles other than unit 2 and unit 1?
What I observe is that the other lights behind what we call unit 1 they have a significant gap between unit 1 and the other vehicles behind them.
Does there appear to be a difference from what you observe? Does there appear to be a difference of speed between unit 1 and the other vehicles?
I'm gonna object to leading in speculation.
Sustained.
From what you observe, what are your observations of unit 1's speed compared to the other vehicles on the roadway?
Judge, this is the same question. I'm objecting to speculation.
Sustained.
Let's go to your investigation supplements. Detective, on page, if I can direct your attention to page 2 of your investigation reports. Did you receive word whether Mr. Fernandez had passed away?
Yes, I did. I put on there that he succumbed to his injuries. So succumbed to his injuries.
Detective, is it your decision after you complete an investigation whether to make an arrest or not?
It is.
What is that? What is the decision to make that arrest based on?
At the scene, I have to have the full probable cause, a complete investigation with all the facts, everything together, to be able to put a charge on there.
Okay. And what factors were you basing this arrest on?
There was a death of a driver. That's one factor. For another vehicle involved, if they're basically driving reckless, basically, there could be a number of things, and this is what I'm looking for. Observed speeding and disregarding red light.
Okay. So just to summarize, it was based on speeding and disregarding a traffic signal?
Correct. Those are the two factors that I observed. I have to have more than one at least to be able to put that into a manslaughter case.
During your investigation, were there any signs that Simon Garza took any evasive action prior to the crash?
I'm sorry.
Based on your investigation, was there any evidence, anything that showed that Simon Garza took evasive action prior to the crash?
No, I could put basically off the data that I collected. He did apply his brakes a second before the crash, but no, from the video, I can't see any try to avoid, try to move, slow down when the yellow light came on or the red light came on.
I'm gonna object that this is speculation from the video, Judge.
All right. That would be sustained as to speculation.
And I'd ask,
Yes.
I'm sorry, I didn't mean to interrupt. I thought you were done, Judge. I'm asked the jury to disregard.
All right, ladies and gentlemen, you're to disregard the last answer and state you'll need to lay foundation.
Thank you, Judge. Detective, I'm going to direct you to the ACM data that you have in front of you.
Okay.
So just refreshing your memory off of that. Was there any sign that Simon Garza's vehicle was containing a constant speed prior to the crash?
I'm gonna object cause for speculation.
All right, and what report is he reviewing?
He's reviewing the ACM report that was used for his recorded
Has
recollection.
it been admitted into evidence?
It has not been admitted, Judge. It's been used to refresh his recollection.
All right, the objection will be overruled.
You can answer.
Based off the ACM collection data, it shows that the vehicle maintain the engine throttle speed. That's basically how the speed of the engine's moving. It made a constant speed up to 1 second prior to the crash.
Okay. What happened 1 second prior to the crash?
It shows that the accelerator, the throttle was let off went to 0. And then half a second after that, the service brake was applied. Service brake, sorry.
To your knowledge, did the ACM show any kind of maneuvering or turning out of the way?
This ACM, like I said, is restricted. Some show that, but this one does not show steering inputs.
Now, based on your investigation, did you believe you have probable cause to make an arrest?
I do.
Did you file for an arrest warrant on Simon Garza?
I did not file for an arrest warrant. I filed at large
Did you file at large?
What does that
And
mean?
what was the charge that you filed the arrest on?
for manslaughter.
Okay, thank you. Judge will pass the witness.
All right, defense.
Thank you, Judge. Hi, Detective.
Hello.
How are you?
Good.
Hi, my name is Marissa Giovenco. I'm representing Mr. Garza. If you don't understand my questions, can't hear me, just let me know, okay?
Yes.
I know we talked about this yesterday, but I want to make sure it's clear. How long have you been a certified peace officer?
Coming up on 13 years, so 12 years and 9 months, maybe
Okay,
10 months.
and so I think I misheard you. You said you made detective in what year?
2023.
Okay, so if I heard 2003, that was way wrong.
Right.
Okay, just making sure. And so since 2023, have you been in TID?
I was in TID for 2 years. Yes.
Okay, so you're no longer in TID.
No, I'm not.
Okay, but at the time of this incident, October of 2023, you were a detective in TID.
That is correct.
And what does TID stand for?
Traffic investigation detail.
Okay. Oh, at this accident, or at the time of this incident, how long had you been with TID?
At the time of this accident, so I got there in May. Let's see, sorry, repress the date. October. So
October.
we're looking at 5 months in TID.
Okay. All right.
Excuse me, just give me one moment.
Yes.
Everyone can remain seated. Sorry about that, everyone. Oh, please be seated. All right, you may continue.
Everything okay?
Yes.
Okay, Detective, you had said, so at the point of this accident, you had been with traffic investigations for 5 months.
That's correct.
So yesterday, you testified that you had investigated probably over 1,000 crashes and 200 death cases, correct?
Throughout my career, correct.
Right. So at this point, when this happened, you were not anywhere near those numbers.
No, that's throughout my career. You still investigate a crash as an officer.
Okay. So in 2023, October of 2023, about how many crashes had you investigated at that point as a detective?
I'd have to go back and look at the numbers at that time. I don't, you're talking about through TID or completely through my career?
As a detective.
As a detective, I had to go back and look at the numbers. I don't have those exact numbers.
Okay. You testified that a lot goes into crash reconstruction, correct?
That's correct.
And in fact, there's a lot of math that goes into a crash reconstruction.
Right, it can be, yes.
Okay, it can be. So do you not always do math in crash reconstruction?
As I explained yesterday, is that when a vehicle moves, it's not locked in that position. The parameters have been taken out. So that part of it you can't use. So there's several formulas that you can use. So let's say there's 30 different equations that you can use for calculating a speed or movement. Some of them are taken away due to parameters that are outside of our control. And we use what we can use.
Okay. And so are you saying, I'm not sure you answered my question. Do you use math in every crash reconstruction or not?
Not in every reconstruction, that's correct, no.
Okay. So did you do any math or any equations to figure out the crash reconstruction in Simon's case?
On this one, there was not enough evidence to be able to put down on paper because you need several variables in a math equation. You need all of them to fit in there to be able to get an accurate number. So we didn't use that on there.
Okay, so no equations were done in this case.
Well, we attempted many, we just couldn't actually get any that would, because you need all the parameters.
Okay. And so when you attempted, do you document that attempt?
No, that's just in my head using, scratch paper or something like that. That's just working in your desk.
Okay. But so the end result is there was no math, no equations to reconstruct this accident.
Right. Again, you don't need them for every equation or every crash. You don't need it. So like I said, if it fits, we can use it. So basically just you pull out your sheet, your chart of your equations. It says you need A, B, and C. Well, if you have A and B, you don't have C, you can't do it. So you attempt it, but if it's not there, you can't do it.
And you would agree with me, there a lot of factors go into a crash and what happens in an accident.
There can be a lot of factors, yes.
Okay. I mean, the conditions of the roadway would be a factor,
Conditions of the roadway can be a factor, yes.
right? The weight of the vehicle can be a factor, correct?
Yes, weight are also calculated.
Okay. What about the year and make and model of the vehicle? That also can be a factor.
Not so much overall, just basically the capabilities of the manufacturer, what the capabilities the manufacturer have for each year. That's the only thing that really changes.
Okay, so are you specifying that a crash between an F-250 is not going to be different than the crash with a smart car?
No, that's what I'm saying. Those are weights. Those are different. Yeah, those are different.
Okay.
Again, applying a brake, making a brake come on, the speed of the vehicle, those remain the same.
Sure, but the year of the vehicle, safety features in vehicles have improved drastically over the years.
Yes,
Okay, so the safety features of a 2026 vehicle is going to be different than, say, a 1996 vehicle.
that's correct.
Okay. Yesterday, the state was attempting to ask you about what speed would be a survivable crash, but all of those factors go into it. Speed is not the only factor to determine whether someone survives the crash, correct?
That is correct. There's different things that could go on.
In fact, more than I mentioned already. We've got whether they were wearing a seatbelt, the point of the impact, alcohol and drug use, whether airbags went off, pre-existing conditions, all of that goes into whether or not someone survives an accident.
That could work as well, yes. Again, those are more for like a medical type thing, but like I said, our focus is on the speed, impact.
Sure. But there's no set speed that determines whether or not someone survives a crash.
There's no set speed. I just go off my observation when I've seen many crashes. Again, experience seeing many survival crashes at 25, 30 miles an hour.
But that's not a guarantee. There's no set speed that people die at.
There are no guarantees.
Right. Okay. And you got to the scene and you one of the first things you did was you talked to my client, correct?
That's not the first thing I did, but that's what's recorded. Because again, in our standard operating procedure, we don't have to record the whole scene we're there. It's just when we interact with a witness, driver, or something like that.
Okay. And actually you testified that one of the first things you do is you look at the vehicles then.
That's correct.
Is that what you did in this case?
Like I said, I do the same thing every time. Talk to the officers, go to the vehicle, look at the video, look at the vehicle, look at the scene, and then I'll talk to the drivers.
Okay. So you talked to all the officers that were at the scene?
No, I do not talk to the handling officer.
Okay. And in fact, you actually, when you got to the scene, you were under the impression that there were witnesses to the offense or to the accident, correct?
When I got there,
Yeah.
again, I don't get that until I get to talk to the officer. I don't know if there's, I mean, because witnesses can leave. I have no idea. Until I talk to the officer, I won't know.
Okay, but that wasn't my question. My question was when you got to the scene, you were under the impression that there were witnesses to the accident.
Under the pressure, under the pressure means I already knew, but I didn't know until I was told by an officer.
Okay. Do you remember making a statement to the handling officer that you thought that there were witnesses?
No.
Okay. Would refreshing your memory with your body cam, or would watching your body cam help refresh your memory?
Sure. I always say there's always witnesses. Like I said, just are they there? Can I talk to them? That's all I want to know is can I talk to them?
Okay. For now we'll move on. You in reviewing your case for your investigation, you review all of the body cameras and reports of other officers?
Yes.
Okay. And so in reviewing those body cameras, you're aware that there actually was a witness who said that Jose Fernandez ran the red light.
Judge, I'm gonna object to that. That's hearsay.
Sustain as to hearsay.
Judge, we'd ask this jury be instructed to disregard the last question.
All right, ladies and gentlemen, you're instructed to disregard the answer to the last question. Or I'm sorry, the question.
Sure. So you're aware that there actually was a witness to this accident.
Yes, the officer told me that the driver, like I said, he's considered a witness to me. He observed what happened. So yes, there is a witness. Is who I talked to is the driver.
Okay. If you testified that you watched all of the body camera from other officers at the scene of this offense, correct?
Yes.
Okay. In watching that, you're aware that there was a neutral, not involved witness to this crash, correct?
Judge, I'm gonna object to this. This is hearsay and it's also been asked and answered.
All right, that objection will be overruled.
You can answer the question.
Oh, yeah. Like I said, I do not recall that, or else I'd have put it in the report.
When you talked to Simon, he was answering the questions. In fact, I think you testified to this yesterday. He was kind of answering them a little slow, correct?
That is correct.
Okay. He had just been in an accident.
That is correct.
Did you ask him if he hit his head?
No, I did not.
Okay. And so it's possible he was in shock.
Like I said, I don't know what he normally talks like. Like I said, I just mentioned that is watching the video. It looks kind of slow, but again, I'm listening for slurred speech. Again, red glass over eyes, stuff like that.
Sure, but that wasn't there. There were no signs of intoxication. Correct?
Correct.
Okay. But he had just been in a serious automobile accident and it's possible he was in shock.
I'm not a Like I said, I'm not a doctor. I don't really know. I mean,
Sure, but Detective, you've testified that you've worked thousands of automobile accidents. Is it not common for people to be in shock after getting into a vehicle accident?
yes, of course, usually they'll get checked out by medical. Medical will give the clear. That's why I said they're already gone. Medical gives the clear. That's why I'm talking to them, not I'm talking to them in an ambulance or at the hospital.
Sure, I'm not asking you to make a medical diagnosis. I'm only asking you if it was possible.
Like I said, anything in the world is possible.
Okay. And when you talked to Simon, he actually told you that he didn't know what color the light was, but that the lady told him the light was red.
That's what I recall from watching the video yesterday. Yes.
Okay. And you checked Simon's phone. There was no evidence that he was using his phone or distracted by his phone.
The two items that I checked were usually text and calls. There's other things that you can use on your phone that won't show up. I mean, if you're watching a video or something like that, you can't see that. Kind of hard to get into a phone. You can't, like I said, if you watch a video on your phone, I can't tell exactly when you watched it. I'm just taking the one thing that we can know.
To non-responsive and narrative.
Sustained.
If you can just listen to my question, there was no evidence that he was using his phone.
There's no evidence that I observed.
Thank you. And in putting together your packet and everything for the district attorney's office, did you also review the EMS records?
I did not.
You did not. Okay. Excuse me. So are you aware that there is conflicting evidence on whether Jose Fernandez was actually wearing a seatbelt or not?
I don't have that information. I just know what I see at the scene is that a seatbelt was worn.
Okay. However, you yourself have actually made a statement that he was not wearing a seatbelt. You remember that?
I don't recall.
Okay. Would watching your body worn camera refresh your memory?
Sure.
Okay. Judge, can we take a break to do that at
Yes.
this point?
All right, ladies and gentlemen, we'll take a 10-minute break. Please remember my previous instructions.
All right for the drink. Sure.
I have a bunch I'll show you since we got a bunch. Yeah. let's put
Lauren,
dark room.
are you able to take this plea?
Yeah.
You good?
Yeah, it's David Gonzalez. I'll walk you through the. All right, the court is calling 2026 CR 001813, State versus David Lopez Gonzalez. Can I have parties announced for the record?
Lauren, for the state.
And are you Mr. Gonzalez? Counsel, have you received all discovery? Did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Gonzalez, did you review the application for community supervision with your attorney? Did you understand it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment? All right, State, it appears that you're proceeding on the indictment as presented. Is that correct?
Yes, Judge.
All right. Mr. Gonzalez, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with unauthorized use of a vehicle as a repeater. So the range of punishment, if the state proves it, the enhancement is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him? Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Gonzalez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 4 years in the prison. You agree that you've been previously convicted of 2 or more felonies for purposes of enhancement. There's a $1,000 fine. The state is opposed to your application. They're taking in consideration 2025 PF 49447 and 2025 PF 49446. Did you understand that to be the plea? Defense is at the plea. State is at the plea.
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions? Outside the agreement, there's to be no contact with the complainant. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? To the enhancements, how do you plead? True or not true? State any evidence. All right, did you review the state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, state in this case, off the record for a moment. Yeah, I just needed, who is S1, the identifiers for that. Unless there's a stipulation that P1 and S1 are the same.
What I tendered to the court judge is there's the initial report of the theft. P1 is listed as Garcia. And then on the pros guide, it should say S1 is. I'm remembering.
Okay, let me see if let me hand it to you and maybe I'm missing something. You're welcome. Okay. Mr. Gonzalez, are you stipulating that the person listed in the waiver and stipulations? Just one moment. That you were the driver of the vehicle? Are you stipulating that you were the driver of the vehicle? All right, after viewing states exhibits 1 and attachments and with the stipulations, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancements true based upon your plea of true and based upon states exhibits 1 and attachments. State is opposed. Are you requesting a PSI? All right, I need a PSI date, please. No, he's on bond. PSI and TAP evaluation. All right, once you sign the reset form, you'll be excused. Make sure that you make all of the appointments that are scheduled for you through probation. All right, thank you. Who's next? Alexander Rivera. And stay, just let me know when he's concluded listening to the video.
Oh, I'm sorry.
Yes. So are we proceeding with sentencing?
Well, you had reset the page from 2 days ago.
Mhm.
Ordered or asked the state to have the main witness be present.
Mhm.
Told that she is not present in this communicated with her. And I believe that she is here. I did not want to having been notified that she might be able to enter into some type of bracelet place. Of course, the court had on the on Tuesday. Stated that she filed a plea bargain. I didn't have a.
Well, I mean, I said that I didn't understand why I should follow this plea bargain agreement.
One of the things that, I don't, would you like me to continue for a moment?
Well, I'm just trying to figure out, so what is the issue with the complaint?
So we were present. When we spoke to her, she said that she didn't want the defendant to go to prison, that she just wanted mental health evaluation and counseling. And obviously she's not gonna be able to do that in prison. That's why we considered that the defendant was a good candidate for deferred adjudication. His criminal background, he don't have
something in 1980 into the place of paper education. So, based on the stipulations, it was the complainant who allowed him to stay at the residence the day of the violation.
You need to sign here. All right, Mr. Rivera, do you understand you're not to have any contact with this person?
Why,
Oh, because there's a protective order. All right, so here's the thing, that's something that needs to be handled civilly, and that needs to be handled through an attorney. What I'm telling you is, one, I have to follow the law. And if there's a protective order that says you're not to have any contact, I can't overrule that on the criminal side because it's a civil matter. So you need to talk to parties over there. So do you understand you can't have any contact with her? There's to be no contact with her. You understand? Do you plan on having contact with her, even though I'm ordering you not to have contact? You'll need to speak with probation, and if you are planning on going there to obtain your items, do you have a third party who can do that?
Yeah.
Yes, then it would have to be them.
I know. Oh, Rivera, that police are well aware of how that procedure can be done. Where
Yes,
they can stand by when personalized items are retrieved that are necessary.
okay.
This is why my eyes.
Okay, so here's the thing. I want you to hear me clearly. The questions you are asking me, I don't have the answer to. The reason why I don't have the answer to it, because protective orders are civil matters. They only become criminal when people violate them. So with regards to why she has a protective order against you, you would need to take that up with the civil court. All right? So 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs. There's to be no contact with the complainant, MIC evaluation out of custody, a referral to Center for Healthcare Services. Are you currently employed? All right, proof of employment within 45 days, no employment as a home healthcare provider or with minors. Field visits 1 time per month until further notice. There's a $1,500 fine, and that will be probated. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Very, very briefly, and what I just felt like my attorney did not provide me.
All right, here's the thing. Do you want to go to a jury trial? All right, then let me just tell you, if you want to go to a jury trial, then your attorney will need to file a motion to withdraw this plea. And I will make a decision on whether or not the plea should be withdrawn or not. But that document is telling you whether or not you have a right to appeal. I followed your plea bargain agreement. You do not have the right to appeal. And I'm going to add no possession of firearms or ammunition. All right. All right, because I followed your plea bargain agreement, you do not have the court's permission to appeal. All right, thank you. Good luck to you, okay?
Thank you.
Oh, no problem.
Yeah, I'll hold them back here and put them here. So.
3 years deferred, yeah. Who's here on Adrian Harper? All right, the court is calling 2025 CR 012745 State versus Adrian Harper. Can I have parties announced?
Safe.
And are you Mr. Harper? Counsel, have you received all discovery? Did you review it with your client? Court will find that the state is in compliance with discovery. Mr. Harper, did you review the true bill of indictment with your attorney? Did you understand it? All right, do you need more time?
No.
All right, did you review the indictment? Counsel, do you waive the reading? State, are you proceeding on the indictment as presented?
Judge, we're waiving the punishment enhancement and also proceeding on the lesser included offense of attempted manufacturing.
Any objection? All right, did you review the court admonishments with your attorney? Did you understand it? And did you sign it in all the appropriate places? All right, the state is proceeding on the lesser included offense of attempted manufacturing and delivery of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses? Okay, everybody stop whispering. The court reporter can't hear, I can barely hear. Thank you. Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Okay. Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the lesser included offense. Punishment is to be assessed at 4 years in the prison. This is run concurrent with 2025 CC 010584, DC 2024 CR 1108, and taking consideration 2026 PF 15451. Did you understand that to be the plea?
Yes, ma'am.
Defense? State.
It is, Judge.
Did you review the waiver of appeal paragraph with your attorney, and did you understand it
Yes.
and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions? Then to the lesser included offense, how do you plea? State any evidence.
Judge, Officer Exhibit number 1, including all attachments.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Okay.
Anything you wish to say on behalf of your client? Then the court will sentence you to 4 years in the prison, give you credit for any time served. This will run concurrent with 2025 CC 010584, DC 2024 CR 1108, taking consideration 2026 PF 15451. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, next we're proceeding in 2024 CR 1108. Did you review the motion to enter adjudication of guilt and revoke community supervision and First Amendment motion to enter adjudication of guilt and revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Adrian Harper who was placed on deferred adjudication in 2024 CR 1108 for the offense of possession of marijuana 4 ounces to 5 pounds on February 22nd, 2024 for a period of 3 years? Is that you?
I am,
State?
Judge will be proceeding on violation of condition number 1, specifically that on or about the first day of July 2024 in Berry County, Texas, the defendant Adrian Jelani Harper committed the offense of Vandal controlled substance in violation of condition number 1.
All right, how do you plead to manufacturing delivery of a controlled substance in violation of condition number 1?
No contest.
That's either true or not true.
True.
State?
Judge will waive the remaining allegations.
Any objections to the waivers? Did you understand by pleading true to violations of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge, we ask that this run concurrently with the previous plea. previously.
And what time are you all asking for?
4 years, revoke 4 years.
We're asking to revoke, Judge, but I believe that it's a state jail, so we'd be asking for 2 years state jail.
Are you asking the court to follow that agreement?
I'm confused on that part.
They're asking that you no longer be on probation, that you be revoked, and that you be sentenced to 2 years in the state jail facility.
We run concurrent 4 years, correct?
Yes. And so are you asking the court to follow that?
Yes, ma'am.
Are you waiving your right to appeal?
Aye.
All right, the court will find you guilty, revoke, sentence you to 2 years in the state jail facility, give you credit for any time served. This will run concurrent with 2025 CR 012745. There's to be no residing in households with minors and no unsupervised contact with minors. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney and that cause number? Did you understand it and sign it?
Yes.
All right, because you entered into a plea bargain agreement and are followed your plea bargain agreement, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Make better choices, all right? Okay, bye-bye. All right. Well, is he applying for probation or not? You all have a no application in this. On Contreras, where is he? Is he applying for probation?
There's 2 different cases.
Okay. All right, have him come up. And what is the status on them having him review the video? I'm sorry?
He's back, Judge.
Oh, his? All right, I'll take this up and then we'll do that. This, yes.
Thanks.
You're welcome. All right, this failure to identify, is this misdemeanor? Okay, you do have a PF number, so I'll sign it.
Thanks.
Yeah. All right, court is calling 2026 CR 005377 and 2026 CR 001785 State versus Omar Contreras. Can I have parties announced?
Roger Pettit for Your Honor.
And are you Mr. Contreras?
Yes, Your Honor.
Counsel, have you received all discovery in each of these cause numbers? Did you review it with your client?
Yes, Your Honor.
And each cause number, the court will find that the state is in compliance with discovery. I think that part. And the cause number ending in 85, did you review the application for community supervision with your attorney? Did you understand it and
Yes.
sign it? And the cause number ending in 77, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.051 and 26.03 of the Code of Criminal Procedure?
Yes, Your Honor.
Did you understand that you have a right to have a grand jury review the evidence in this case and make a decision on whether or not to hold you over for trial? And your attorney has a right to the passage of 2 days upon presentation of the information and 10 days to prepare for trial?
Yes, Your Honor.
By entering this plea, you're waiving those rights. Are you intending to waive those rights and enter into a plea in this case?
Yes.
I did.
Court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. In each case, did you review the felony information and also the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, are you waiving the reading?
Yes, Your Honor.
State, in each case, are you proceeding on the bills as presented?
Yes.
The Contreras and the cause number ending in 85, you're charged with driving while intoxicated, third or more. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. And the cause number ending in 77, you're charged with evading arrest, detention as a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering a plea in each of these cause numbers, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes.
Counsel, in each cause number, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he is currently competent and was legally sane at the time of the offense?
Yes.
Mr. Contreras, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promise you anything other than the plea?
No, Your
Are
Honor.
you satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, by entering these pleas, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, Your
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea and the cause number that you're moving on by information, the state is asking that your punishment be assessed at 3 days in the Bexar County Jail under 1244. Did you understand that to be the plea?
Yes, Your Honor.
Defense and state?
Yes, Your Honor.
And the cause number where the state is proceeding by a bill of indictment, they're asking that your punishment be assessed at 5 years in the prison. There's a $1,000 fine. State recommends community supervision. They're taking in consideration 2026 CR 001247. There's to be ignition interlock for half the term. Did you understand that to be your plea?
Yes, Your Honor.
Defense and state?
Yes, Your Honor.
And each cause number, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, any such motions?
No, Your Honor.
Outside the agreement and the cause number ending in 85, the state is asking that your community supervision be for a term of 5 years. There be a TAP evaluation, 30 days in the Bexar County Jail, 100 hours community service restitution, DWI intervention, and VIP plus 1 year driver's license suspension. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then in each cause number, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
No, good.
In each cause number, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. Okay, off the record for a moment. Cases that the judgments that are contained in the stipulations are in fact your client? And Mr. Contreras, do you stipulate that the judgments that are contained in the waivers, you are that person who's listed?
Yes.
All right. Then in each cause number, the court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Your Honor, we just have the 30-day, if you were to approve the request, we just have some discussion on the house, potential house arrest, if that's it.
All right. All right, so we'll proceed first with 2026 CR 005377. Is that a judgment satisfied?
Yes.
So in that cause number. Sorry, I'm waiting for it to pull up. Court will find you guilty. Court will sentence you to 3 days in the Bear County Jail under 1244. Court will show that the judgment is satisfied. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, next we're gonna move into the cause number ending in 85. Are you currently employed?
Yes.
And what do you do? All right, and does your employment take you outside of the county?
No, ma'am, I stay inside.
Okay. All right, this is what the court is going to do. And I'm sorry, do you live by yourself or with someone else?
I live with.
Okay, so this is what the court is going to do. Court is finding you guilty. Court will sentence you to 5 years in prison, suspended and probated for 5 years. There's to be regular reporting by Zoom or in person, regular random UAs, proof, and make sure you test for alcohol. There's to be proof of employment within 45 days, no employment as a home healthcare provider or with minors. Do you have a vehicle at your home?
No, you're.
All right, ignition interlock for half the term or a portable alcohol monitoring device with an affidavit of non-driving. There's going to be field visits one time per month for 6 months. DWI intervention, VIP live, 2-year license suspension. 100 hours of community service restitution. 1 hour will be deducted for every sober support meeting that is completed. All right, there'll be 30 days partial GPS for employment. Any objections from the state? All right, so there'll be 30 days GPS, waive fees, partial for employment in lieu of 10 days at the Bexar County Jail. The court is finding that if the defendant were to serve the 10 days in the Bexar County Jail, it would do hardship with his employment and his ability to support himself financially, and also it's to alleviate the crowding at the jail. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
Oh, yeah.
All right, and I'm so sorry, do a TAP evaluation out of custody. And if the TAP recommends inpatient treatment, we'll start with outpatient treatment. All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, sir.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. We can go off the record. Here's the thing, DWIs, I have yet to meet somebody who said, you know what, I'm gonna drink to intoxication and then I'm gonna get out and hit somebody. But people get killed every day, and Fiesta is upcoming. Don't even partake in Fiesta because that's too much temptation for you, okay?
Yes, sir.
All right, good luck to you. Yes, could you line the jurors up? Yes. All right, who are the two resets? Who is it?
I'm wearing Prada. I really liked your flower pen. I almost took a picture of you with it.
Montez.
It was great.
Where are you?
Thank you for stepping in.
No problem, no
Sat
problem.
down
No.
like that.
We're here, we got each other's backs.
Okay,
No, I'll pull that out.
all right.
This is- we'll wrap it up.
Let's see if that's
We're doing a dance here in a minute.
prudent, yeah.
There's no-
All right, where are we on discovery?
I'm burned.
Hi.
We've got all this.
Lauren, yeah, Lauren is smart.
All right, has an offer been tendered?
So you did this, right? Yes, Tom.
Yeah, just remember to do yourself as Brandon.
All right, Norma,
Credit.
set this for a plea deadline date, mid-May.
Thank you, my friend.
Is that true? You guys want?
Okay.
You guys want?
All right, after the 15th.
That is already.
All right, once you sign the reset form, you're excused. Yes,
That order, well, and custody.
no, out of custody.
And then I think we just wanted to make sure we did this.
Okay. What's this, what's the case number?
00317.
All right, so in that case, I know it's 3 years deferred adjudication, regular reporting by Zoom or in person. There's to be no contact with the complainant, referral to Center for Healthcare Services, NIC evaluation out of custody. And let me see what else I added. Odyssey just pulled up. Proof of employment within 45 days, no employment as a home healthcare provider with minors. Field visits one time per month until further notice. $1,500 fine, probated, and no possession of firearms and ammunition. Okay, sure, no problem. Okay. I will do it, show you.
Yeah. you're wrong. What do you mean? I'm so sorry if my breath is like. Oh, okay. I mean, I wasn't gonna say anything.
It's 5. Uh-huh.
We'll deal with them, there's just some level right now.
I'm sorry, which page? Delozer? And we're just waiting for,
Oh, there's
come
Cindy.
forward, Delozer. Hello.
Yes.
So you need one.
Please, no, I will not.
The jury in. Yes. And I'll put it in the system.
Honor, on Rivera, our photo specialist report was asking if the Mickey Bell then the board cases.
Yeah, I mean, you all need to put that on the record because anytime there is some change that is to a detriment of an accused, it has to be on the record and they have to come back. Okay, so, yes, sure, no problem. So he'll need to come back
Yes, sir.
or either can appear by Zoom. All right, let's bring the jurors in.
All right, for the jury.
All right, you may be seated. All right, defense, it's your witness.
Yes, thank you, Judge. Okay, Detective, now, after having reviewed your body camera, you recall making a statement in reference to Jose Fernandez that he just wasn't wearing a seatbelt.
I made a statement to the owner of the bar, they were not wearing a seatbelt.
Eh,
I didn't say who it was. It's out of context. I don't know. He could talk about anybody. Because he talked about several crashes while we were watching that video.
Okay. But the conversation was about someone getting thrown from a windshield, correct?
During that conversation, he said something about somebody being thrown through a windshield.
Right. And y'all are there watching the video of the crash that we're here for.
Right, but again, during that video, we spoke of many crashes that he was telling me about in front of his bar.
Right. And he says something about a guy getting thrown from the windshield, and you responded with, no, he just wasn't wearing a seatbelt.
Judge, I object to that. This has been asked and answered, and also it's not relevant to this crash.
All right, that objection will be overruled.
You can answer.
Yeah, like I said, I can talk when I'm talking to them, building rapport. So
I'm gonna object to non-responsive. It's a yes or no question, officer. He says something about somebody getting thrown from the windshield, and you responded with, no, he just wasn't wearing a seatbelt, correct?
I believe those are through the words.
Exactly. Thank you. Okay. There was some communication yesterday about the locking mechanisms in a seatbelt. Correct? You remember that?
Correct.
Okay. You'd agree with me that older vehicles don't have that locking mechanism. It's changed in the newer vehicles. It's a little different.
I can't speak on manufacturers. That it's been around a pretty long time.
Okay. 1 second. So are you aware that older vehicles do not have charges in them in the seatbelt?
Again, I have to go back to the manufacturer. I don't know each one. I just know that they have a locking mechanism.
Okay. And so you cannot testify if the 1996 Honda involved in this actually had the locking mechanism in this vehicle.
Correct. I don't have that on my data.
Okay. However, yesterday you testified that the seatbelt was locked.
Correct. From my experience and training, I observed it being locked.
Are you aware that the 1996 Honda is actually known to have seatbelt issues with the retraction?
Again, I don't know everything about Honda Civics of that year.
Have you ever been to a crash where you expected a seatbelt to be locked, but it wasn't?
I do not recall.
But yet you've been to thousands of crashes, correct?
That's correct.
We also watched another body cam that we talked about earlier. You had testified that you watched all of the other officers' body cameras. Now having re-reviewed Officer Rodriguez's body camera, you recall there was actually a witness stating that they did witness the accident, correct?
Did we watch that?
We did. It was the first one we watched.
Okay, I still didn't hear him say that in there. I didn't hear him.
So are you saying you didn't hear what he said, or are you denying that he stated that he witnessed the accident? Just to be clear.
I didn't hear him say that. Like I said, and I don't want to speak on his behalf of his statement.
Okay, I just want to make sure I understand what you're saying. Are you saying you didn't hear what he said, or you're saying he did not say that he witnessed the accident?
Judge, I object to hearsay, cumulative questioning, asked and answered.
All right, ask and answer is overruled. He has yet to answer the question.
We'd urge hearsay then.
With regards to hearsay, could I have parties approach?
Yeah, but that's a different one. I'm so sorry, Cindy. Can you repeat my question? Because I don't remember what I said.
I just want to make sure I understand what you're saying. Are you saying you didn't hear what he said? You're saying you did not say that you witnessed the accident?
And you can answer the question.
It's not very clear. Are you asking? I'm not even sure what you're asking.
You said I didn't hear that. So are you saying you couldn't hear what he was saying in the video? Or are you saying that you didn't hear him say that that's not what he said?
I didn't interpret it as that when I watched the video.
Okay. So you're denying that he said he witnessed?
I'm not denying, I just didn't hear it.
Okay.
To deny, he would say he didn't say it.
Okay, so you testified that you are the one who determines whether probable cause exists at the scene to make an arrest, correct?
That is correct.
Okay, and no arrests were made.
No more arrests were made on scene. That's correct.
Okay. And you're telling this jury that you have probable cause for manslaughter at this point, correct?
Yes, when I presented my case to the prosecution guide, it had enough evidence to pursue a manslaughter case.
Okay. But the only thing that has changed is Mr. Fernandez's death, correct?
I was able to confirm the speed, get the video, see the actual running the red light. So the speed was confirmed. This red light was confirmed, and the death was already confirmed that evening. So again, I didn't make the rest of that until I confirmed the speed and the violation also.
Okay. Well, let's talk about the crash report. You worked on the crash report, correct?
I do not, I just do a supplement, adding the additional stuff to the original officer's report.
Do you still have a copy in front of you?
Yes.
Okay.
Well, that would be Selena's thing. Or just.
No, that's,
I'm sorry, just to be clear, you have yours and Selena's or just yours? Or just Selena?
where's it? Yes, it is.
I have both.
Okay. And so. Okay, so in comparing the two, you took Selena's crash report and you made updates, correct? You supplemented it, would be the proper word.
I'd have to review the whole document to see what's the side by side, what any changes that I made. The only note that I made is in parentheses, I put asterisks next to it. The only update I made is that driver of unit 2 succumbed to his injuries and was pronounced deceased at 0951 hours at University Hospital.
Yeah.
That's the supplement that I made.
Okay, and I'm sorry, I wasn't asking you the changes yet. But I'm saying you took his crash report and you supplemented it.
It's just adding information, which was that sentence.
Exactly, that's a supplement, right? You didn't write the whole report.
No, I did not.
Okay, that's my point. In fact, I think you testified yesterday. I want to find the exact notes. If I remember correctly, you testified that you add all of the pertinent details. Does that sound right?
That's correct.
Okay. So you added that Jose Fernandez passed away. That is in the paragraph.
Judge, I'm objecting to that. Defense counsel is referring to something that's not in evidence. Perhaps if she would refer to the officer's report, he can refresh his recollection and testify there. But she can't testify directly from something that's not in evidence. That's improper.
All right, so what is your objection?
Defense counsel reading from an item that is not in evidence.
All right, that'll be your response.
Judge, I'm not asking him to read from the document. I'm asking him if he added to the paragraph.
She's reading from the paragraph into the record.
All right, the objection is hearsay,
In that case, Judge, I'll also object to hearsay.
and your
Because
response to hearsay and,
he's already testified that he added that the decedent passed away.
all right. So are you testifying that you supplemented someone else's report?
No, Judge.
All right, you may ask your questions and the court will make a ruling.
Okay. Now you're saying you did not supplement his report?
An original and a supplement, they're two different reports.
Okay,
They're not the same report.
okay, however, the report that has your name on it, you did not write in its entirety, correct?
Correct. I make notes of what I entered, and that is it.
Okay. Uh, on the first page, you talk about there's codes, right? For the people in unit 2,
On the crash report,
correct?
okay.
That's what we're talking about, right?
Okay,
Still-
I didn't, yeah, again, I didn't write that report.
But you just said it's a different report and that one has your name on it.
TxDOT does not separate them. They're not able to separate two reports. My only entry is what my initials are directly on that on your page 204. That's the only thing that's different.
Okay, so the code that actually states that Jose Fernandez is now deceased when he was not deceased at the original time of the report, you didn't do that?
Right, that's the entry that I made. I note the entry that I make.
And that's what I'm asking you about. Okay. But you didn't add any pertinent details as far as to the diagram, correct?
That's correct.
Okay, so any errors that were in the diagram, you did not correct.
Correct.
So any directions of the vehicle or where the vehicles ended up, those wouldn't be pertinent details that you would want to add.
Not in that report. That's the officer's report, and I don't want to change that. If I make any changes, it's going to change it.
Okay. Is it concerning to you that there is only one causation as far as contributing to the accident, one contributing factor listed on the crash report?
No,
It's not concerning?
that's what the officer wrote at the time. and That's what
Okay.
he believed, and he knows.
Okay. And it wouldn't be concerning to you when the multiple factors are what are the allegations that we're here for today?
Right, that's why I write them in my supplement right here. My investigative supplement.
Right, so, but this crash report is every detail that you said, pertinent details that go towards this accident, correct?
Being pertinent as if it wasn't an identified driver, I'll put the person's actual name in there. But again, I'll make notes of that I put that person there because identification was made. Person deceased, I put their information in there.
Right, so you updated it with the pertinent detail, your words, that's Mr. Fernandez passed away, but you didn't update it with any other contributing factors to the crash.
That is correct.
Those weren't pertinent.
TxDOT requires that I enter the date of the death and the cause. The cause, the code that she referred to. I am required to put those two information in there.
And that code is K, correct?
Double check, yes, but I believe it's K.
Okay. Oh, I'm sorry. One other thing on the crash report. You don't update any toxicology results on the deceased, correct?
If I had them, yes, and I request them, yes.
Okay, but we had toxicology in the medical records for Jose Fernandez and you didn't update that on this crash report, correct?
They're not given to me and I did not request for them or put a subpoena in for them.
Okay. What about an open container? Is that important to a crash?
It can be for if the officer observed it, they can put it, give the person a ticket.
Okay. But no one was given a ticket for having an open container in this incident.
I do not believe so.
But you're aware there was an open container in Jose Fernandez's vehicle, correct?
Again, I can't, like I said, that's the officer who wrote that. A container can also be bursted open by a crash.
Okay, that wasn't my question. You're aware there was an open container in Jose Fernandez's vehicle, correct?
I can't exactly say if it was open or not, because like I said, the video I see a container there, and again, I don't know if it was opened or crushed open by the crash.
And there's, you actually went to the scene
That's correct.
and you saw Jose Fernandez's vehicle,
Yes, I saw the Honda.
okay? And you saw the open container inside the vehicle?
I observed a can in the vehicle. I did not pay attention if it was open or closed.
Don't you think that that's important to a crash investigation and whether someone is driving with an open container?
That's for the officer. If they observe it, it has to be observed by the officer.
Okay, can you listen to my question? Okay, don't you think it's important to note whether there was an open container in a vehicle when there's a crash?
Again, you
Yes
have
or
to
no?
have,
Yes or no?
it can be.
Okay. When would it not be important that someone is driving with an open container when they've been involved in a motor vehicle accident?
So whenever we're at the scene, somebody says, hey, the person smells like intoxicants, strong odor, go to the hospital. They say they have a strong odor, then that's significant.
Okay, and so driving with an open container, as long as you don't smell like alcohol, you're okay, it's not important?
Now, I think the traffic code says that if it's officer observed, they give them a ticket.
Right. It's against law to drive with an open container, correct?
Okay, yes,
Okay. And drinking while driving impairs someone's driving, does it not?
it can, yes.
Okay. What about smoking marijuana before driving? That will impair your driving.
It could, yes.
What about doing cocaine prior to driving? That will affect your driving.
Yes, it could.
What about the combination of all three substances? That will affect someone's driving.
It could.
But that wasn't important to your investigation.
I didn't have any of those information with me.
But you had the open container, you saw it.
I can confirm that the driver was the one who consuming of any of that alcohol.
Sure. However, have you ever seen a open container in a center console and given the driver a ticket, even though there were other people in the vehicle?
That's correct. So I observed it. I can give that person a ticket. Again, the officer will have discretion to be able to give a ticket.
But you didn't observe the driver drinking, you just saw it in the center console and assumed it was theirs, correct?
I didn't observe that. Like I said, I observed the can. I didn't observe it was open to the point where somebody is maybe opening it to drink it.
Right, I'm talking about in the past. You said you have seen a open container in someone's center console and given the driver a ticket for an open container, even though there were other people in the vehicle, correct?
I'd have to go back and check my records. I don't actually think I've ever given that kind of ticket.
Okay,
Again, yes, that is the law. That is a state law.
okay. And so wouldn't you agree with me that it's due diligence for you to check a beer can to see if it's cold to the touch, if it's in the vehicle and someone was just in an automobile accident?
Again, I observed the can in there. That's all I have to do is be able to observe the can. It's on video and pictures.
Okay, let me ask my question again. Wouldn't you agree with me that it's due diligence for you to see if a can of beer in someone's vehicle after an automobile accident is cold to the touch?
Yes.
Okay, did you do that?
No,
Okay. And to your knowledge, did any officer at the scene do that?
I do not know that.
Did you question any of the occupants of Jose Fernandez's vehicle about the open container that was in their car?
I did not.
In your investigation, did you learn of any officer questioning anyone in the vehicle about an open container?
I did not.
Did you also have, is it your decision on what citations are issued?
It is not.
It is not. Okay. Are you aware that Simon was only issued a ticket for no insurance?
That was on the officer report, but I don't tell them to write that report, that ticket.
Okay. Okay, but probable cause, so if you have probable cause now for a manslaughter after Mr. Fernandez is passed, why wouldn't you have had probable cause for an aggravated assault at the scene?
The elements aren't there.
Okay, but the only difference is someone passed away, correct?
No, it's the speed of the vehicle and the disregarding the red light.
Okay. And you didn't know either of those factors at the scene of the crash?
That is correct.
Okay. And it took you a year and a half to find those, to learn that?
No, I think if I look at, can I look at the date? Yeah. So the vehicle speed was observed on 11/10 of 2023, which is a month, a little under a month.
Okay. And so at that point, you went and got a warrant?
The warrant is before that to get the ACM.
No, I'm talking about for my client.
I did not get a warrant.
Okay. Did you present the case to the district attorney's office?
I did.
When did you do that?
I look at my notes. Here. Submission date shows November 24th of 2023.
Okay, November 24th, 2023. And you said, what was the date you said you learned of the speed?
It's November 10th.
Okay. And so without speed, you wouldn't have had enough, running the red light alone would have been not enough. Is that what you're saying?
That is correct.
Okay. What's failure to maintain a proper lookout?
Proper lookout?
Mhm.
I'm not sure what you're referring to. Can you elaborate?
I mean, that's the question. What is there an offense for failing to maintain a proper lookout? Have you ever heard that before?
Like as if you're a lookout for a criminal act?
You know,
You're the lookout while somebody else is doing the criminal act?
It's a very good question. These are things the state is alleging. So have you ever heard of that? Is that an offense, a traffic offense that you've heard of? Failing to maintain a proper lookout?
You'd have to be more clear. Again, I don't really understand what you're asking.
Okay, there is
You're
not.
taking one little piece out of there, but you have to explain what
Yeah.
what you're referring to.
Sure, there is not a traffic offense called failing to maintain a proper lookout, correct?
There's not a traffic offense. It's within a traffic offense.
Okay,
That's why I'm asking you to elaborate because
within-
it says within the traffic offense. It's not a specific traffic law violation.
okay, what traffic offense is it within?
Within basically for stopping at a yellow light, maintaining, observing traffic controls,
For stopping at a yellow light,
a red light.
at a red light? Okay. One second. So speeding is what changed to you to give you probable cause for manslaughter is what you're saying.
That is the element that I needed as well. Yes. Correct.
Okay.
With the red light.
Okay. And so if every person who speeds on the road committing an attempted manslaughter?
Unless they cause the death of another person while committing another violation. It has multiple violations while committing a death of another.
You requested the manner and death of from the medical examiner, correct? The cause and manner of death?
That's correct.
Did you review that?
I don't have it with me up here, but yes, I did.
Okay. You'd agree with me that the cause of death was blunt force injury related to renal carcinoma, correct?
Again, unless I see it in front of me and
Okay, well, you can use your report to refresh your memory.
I need the autopsy report.
No, your report. You talk about it in your report. about second paragraph from the bottom, from the conclusion.
Correct? Yes.
Okay. And officer, I'm sorry, detective, the legal limit for your blood alcohol in driving is 0.08, correct?
That's correct.
Anything above a 0.08 would be an intoxicated driver,
Yes.
and that's only alcohol. Additional substances would definitely affect the level of intoxication.
Yes, we have to have the measurement of what it, how much they have in the.
Great. Okay. And officer, I'm sorry, detective, you went to the A's Up Sports Bar to collect the video that is still on the screen, correct, of the crash?
That is correct.
Okay. And you remember talking to the sweet old man who owns the bar?
The owner of the bar, that's correct.
Yes. Okay. You remember telling him that this is just an accident, it's nothing criminal?
I do not recall. Again, I can talk to them. A lot of people don't like to hear bad news, so I'm just basically creating a rapport.
So if you said that you were lying to him?
I'm just talking to him.
Okay. But do you remember telling him multiple times that this isn't anything criminal, it was just a crash?
Again, just building rapport with the person who's gonna share video.
Okay, just a yes or no. Do you remember telling him, I want to say 3 or 4 times, that this is just an accident, it's not criminal?
Again, I didn't watch that in the video showing back there, so I'm guessing you saw it. I don't recall.
That's the answer. You don't remember saying that. Okay, so would reviewing that in your video help refresh your memory?
Sure.
Judge, if we could take 30 seconds.
Sure. All right, ladies and gentlemen, if you will give us 30 seconds, I'd say 5 minutes.
Maybe.
All right, great.
Thank you.
Hold on. I gotta get it. Hold on. Let's see. Mhm.
All right, if you'll step down so they can show you what they're talking
You're right.
about.
Oh, right here. And this was the one. Oh, it's still up. I think he requested it. I know. I'm getting there. Yeah.
And then it was actually done. It was actually done on the 23rd.
But he went to the hospital, critical. Yeah. And, ended up passing. Oh, he did? Yeah. So, like I said, we don't investigate it that way if there's no, even still, I don't have to invest, I'm not. It's a crash. Yeah. You know, it's not a criminal act. So. But nobody dropped that. Right.
All right, everyone, please be seated. And defense, it's still your witness.
Thank you, Judge. Okay, officer, you watched your body cam now.
I'm sorry?
You watched your portion of the body cam now,
Yes,
okay? And you recall stating that this isn't anything criminal, it's just a crash.
yes,
That's the witness.
Right. State.
Very quick questions, Judge. Detective. In regards to that statement, do you recall when it was made?
you're talking about the video,
The
the
date.
statement I made? Yes, saw it on top of our camera, I believe it's the 24th.
Okay,
I remember, it was after the crash, when I was going to get the video.
okay.
Hang on, no, there's no time up there.
Was it, how about this? When was it in relation to when you got the report of the speed back?
It was prior to that,
So it was before you decided to file charges?
correct.
Pass the witness.
In fact, you also stated that you can't take someone to jail for running a red light, right?
I didn't say that.
You didn't say that?
No.
And if speed was a factor to the crash, don't you think that that's a pertinent detail that you should update on the crash report?
No, again, I'm not going to change the officer's crash report and the speed because it wasn't relevant at the time the crash report was written.
Okay, but you testified that you're supplementing the crash report to add all of the pertinent details.
Can I look at, is there a block for the
Well,
speed?
just listen to my question. You testified that you supplement the crash report to add all of the pertinent details. Was that not the exact words that you said?
Okay, yeah, there is not a speed block to enter onto the crash report.
Officer, I'm sorry. Please just answer my question. Okay, I'm asking you. You testified that you supplement the crash report to add all of the pertinent details, correct?
That is correct.
Okay. Now, you're trying to tell the jury that there is not a portion for how fast the car was going. I understand that. Look at page 2. There is a spot that says contributing factors to the crash. Is there not?
Correct.
Okay. You did not supplement to add speed as a contributing factor to this crash.
Correct, because I put it on my.
I did not ask you why.
All right.
Thank you. And but you did testify that you would supplement to add all the pertinent details. And you can, there's no limit on how many times TxDOT will allow you to supplement a crash report, correct?
Correct.
You also did not supplement it to add any intoxication or narcotics usage to Mr. Fernandez.
Correct.
Pass the witness.
No further questions, Judge.
All right, is this witness excused or subject for recall?
He is excused by the state.
Subject to recall, Judge.
All right, if you can just remain in the vicinity in case either party wishes to recall you. The rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of this case.
Yes.
All right, thank you. State, call your next witness.
State calls James Wilkerson.
No, I just.
Timberland?
I just.
I got it. I'm gonna find it. That's what I'm looking for. I printed it out.
So can you raise your hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, just have a seat, and if you'll state your name for the record.
James Andrew Wilkerson the fourth.
All right, state, you may proceed.
Mr. Wilkerson, how are you presently employed?
I'm employed by the Bear County Medical Examiner's Office.
And what are your duties at the Bear County Medical Examiner's Office?
I perform autopsies and investigate deaths.
How long have you been in this field?
I've been doing this for 35 years.
What is your educational background that qualifies you in the field of medical pathology?
Graduated from Birmingham Southern College, then went to medical school, University of Alabama on a scholarship. Then came here and did my residency at Brooke Army Medical Center, leading to board certification in anatomic and clinical pathology. Served 3 years at Fort Polk, then went to the Armed Forces Institute of Pathology in Washington, D.C., and did a forensic pathology fellowship, which led to board certification in forensic pathology.
Okay, so is it your testimony you maintain 2 types of board certification?
Actually, three. It's all pathology, but it's 3 different times.
And what is forensic pathology?
Pathology literally means the study of disease, and it's a branch of medicine that is primarily concerned with diagnosis. And you probably will never see your pathologist. They look at surgical specimens and they look at lab values and make diagnoses. But forensic pathology is a subspecialty of pathology that's concerned with investigating the cause and manner of death and performing autopsies to determine how and why people died.
Okay, and I want to discuss a little bit what is a manner of death. Can you explain that?
A manner of death is the facts or the circumstances that are present at the time of the death, and it's an opinion by the forensic pathologist as to what the circumstances are. We have 5 manners of death that we're allowed to use. The first is natural, which is what most people die of, natural disease. Then there's suicide, where someone kills themselves. There's homicide, where another person kills someone. There's accident, where someone dies during their normal life of an unintentional or unforeseen act. And then there's undetermined, where we don't know the circumstances, or we can't come to a conclusion as to what the circumstances were when the person died.
Okay, and what is cause of death?
Cause of death is the disease or injury that led to the person's death, the specific disease or injury that led to the death.
And in your capacity at the Bear County Medical Examiner's office, have you performed autopsies?
Yes,
On few or many occasions, would you say?
approximately 400 a year here at Bear County,
So how many would you estimate over your career?
approximately 13,000.
And what is an autopsy?
An autopsy is a study of a deceased person. We start by having full-time investigators that go to the scene of any death and try to help us figure out what occurred so that we can eventually assign a manner. Then the body is placed in a sealed bag and brought to the medical examiner's office. In the morning, we determine what exam we're going to do and how extensive the exam is. We usually open the bag and document any injuries, look at identifying features, collect any trace evidence. We'll also draw toxicology studies and do any x-rays at that point in time. Then clean the body and re-document all the injuries with both photographs and drawings. And then at the end of that period of time, at the end of the external exam, we will do an internal exam and examine all of the organs for the presence of disease or injury.
Okay. Have you previously testified as an expert in forensic pathology?
Yes.
Approximately how many times would you estimate?
I'm going to interrupt just briefly, Judge. We'll stipulate this doctor is an expert.
All right. They say they will stipulate, but state you're allowed to ask what questions you wish to ask.
Approximately how many times would you say you've testified?
Approximately 350 times.
Okay, now I want to talk to you a little bit. Are you familiar with a decedent by the name of Jose Fernandez?
Yes.
Do you recall Mr. Fernandez's age?
He was 50 years old.
What was his sex?
Male.
Okay. Did you conduct an autopsy on Jose Fernandez?
No, we did not. If a patient spends a long time in a hospital and their injuries are well documented, and there's nothing to be gained from performing the autopsy, we will not perform the autopsy.
Okay. So is it your testimony that you reviewed all the documentation regarding to Mr. Fernandez then?
Yes, I did. And also his family, because of his injuries that were non-recoverable, his family had decided to release his organs for donation. And so we reviewed all of the records to allow a donation to occur, making sure that none of the organs to be donated would interfere with our investigation of the cause and manner of death. And then we reviewed the medical records to determine the cause and manner of death.
Okay. So I want to break down what you've talked about a little bit. We're going to start with, you mentioned, but right before this, sign on the cause. Who is allowed to sign a death certificate?
In the state of Texas, any doctor who has a license can sign a death certificate, but they can only sign natural death certificates unless they're a medical examiner.
I'm sorry, you testified only doctors can sign on natural cause of death. So only one of the 5 total causes, is that correct?
That's correct.
Okay. And so based on your review of the documents relating to Mr. Fernandez, can you tell the jury what injuries he sustained?
He had severe injuries to his head. That was the main injury that persisted for at least a week of time, and he was not improving. He had other injuries to his body, but the family decided at the end of that week that they wanted to do comfort care and release his organs for transplant.
Okay, now you said organs for transplant. Are there ever times when organs may not be suitable for transplant?
There are times when an organ is injured or has disease that it won't be suitable for transplant. We sometimes have problems if it's a case where the cause of death is not clear. We don't want to release organs that could help us define the cause that we don't know. In other words, if we're going to do an autopsy because we don't know why they died, we don't want to give those organs away and not be able to figure it out.
So here was Mr. Fernandez's organs. Were they able to be harvested?
They could have been harvested, and they were all ready to harvest when they discovered that he had a malignancy, a renal cell carcinoma of his kidney, and that had metastasized to his brain. And that is an exclusion for donation. They don't donate organs from people who have cancer.
Have you previously examined reports where the decedent suffered injuries inflicted by a motor vehicle accident?
Yes,
On few or many times?
many times.
Based on your review of the files here relating to Mr. Fernandez, did you find his injuries consistent with that of a motor vehicle collision?
Yes.
In what way?
In that he had the head injury, he was T-boned by another vehicle, and that energy from that vehicle was transmitted directly to his body in a perpendicular fashion. That those can really be devastating injuries because there's nothing to protect the body but the door of the vehicle. And he had injuries that were consistent with that, and they were well documented in the medical records.
Okay, and you spoke a little bit about Mr. Fernandez's renal mass. Is that a notable finding, would you say?
Yes.
And is that renal mass, or I guess, is his renal system something attributable to his death?
It was contributing to his death. In other words, because he had cancer, it helped him have death as well.
Okay, but you can't say that that was the sole cause, is that correct?
No, that was not the sole cause.
During your review of the documents, did you find any evidence of disease that would prevent him from living at the time of the accident?
No.
No. Were his injuries alone sufficient to cause death in this case?
Yes.
I want to talk to you a little bit about serum ethanol. Are you familiar with that?
Yes.
What is that?
Serum ethanol is a testing of a blood ethanol on the fluid portion of the blood, as opposed to the fluid and the cells. And it's a test that's usually done in the hospital to determine if the student had alcohol in his system for various treatments and therapies.
Does that differ from whole blood?
Whole blood alcohol is a medical legal test that is used to determine the level of alcohol that a person was under the influence of at the time of their death and present that data in a court of law.
Okay, so it's your testimony that the test to determine serum ethanol in whole blood differs.
Correct.
Are you aware whether serum ethanol was testing, or I guess serum ethanol screening was done on Mr. Fernandez?
Yes, it's usually done, the screenings test, and they usually do a urine drug screen as well on all of their trauma patients.
Now, I want to ask you, generally speaking, regarding pathology, is screening different than confirmation testing?
Yes, we do. For forensic pathology, for forensic testing and legal testing, two tests have to be performed to call it positive. A screening test is a test that is very, very sensitive. In other words, a pregnancy, a urine pregnancy test that you might buy is a screening test. Some of these new COVID tests that you might buy is a screening test. But they may not be specific because they're so sensitive. They may pick up other things that aren't meant to be positive on the test because they're looking to grab everything they can. And when those are done, then we turn around and we do a very specific test that is unique to that agent or that entity. And we usually use what's called a gas chromatograph and a mass spectrometer. And the substance is run through that machine and its molecular structure is determined, which means that it's only that drug. And then the size of the graph that's present associated with that drug is the concentration determination of the drug. And that's what we report to the legal system.
Okay, so to do the mass spectrometry and the gas chromatography, where do the specimens get sent to get those tests done?
We do those at our office. We have a forensic toxicology laboratory at our office. The hospitals would have to send it out to another lab, another forensic toxicology lab to have that work performed.
Based on your review of the documents in this case, did the hospital send the specimen to toxicology?
No, they did not.
So only a screening was done.
Correct.
So it's your testimony that only the serum ethanol was determined for Mr. Fernandez.
That's correct.
Okay. So is it also your testimony that the blood alcohol concentration of Mr. Fernandez was not determined?
Correct. It was present, but it was not, the absolute concentration for legal purposes was not determined.
What were your findings as to manner of death of Mr. Fernandez?
We found an accident.
Okay. In making determinations, do you confine your consideration to the examination of the body itself, or do you also consider outside circumstances?
We also use the records, the medical records. We use the investigation from our investigators and other investigators, including the police or any other agencies, public agencies that have reviewed the wreck, usually the car wreck usually, and made a determination or report.
Okay, in this case,
Do you have an opinion as to the cause of death of Mr. Fernandez?
I'm gonna object, I asked and answered.
Overrule.
The cause of death is blunt force injuries, particularly blunt force injuries to the head. Blunt force injuries are when the body strikes an object or an object strikes the body and produces injury.
And now you testified earlier that Mr. Fernandez the injuries were recoverable. Is that correct?
Yes,
Why is that?
because the degree of injury to the brain and bleeding in the brain was not something that resolves.
Now, regarding the cause of death, regarding the manner of death being accident, that doesn't determine fault, correct?
Correct.
I pass the witness, Your Honor.
Defense.
Yes, Dr. Wilkerson. Let's start with the drug and alcohol testing. You talked about the serum testing versus the legal testing. While they are different, there is a mathematical equation that can convert a serum blood test to the legal equivalent, correct?
Yes, but we don't use that in our practice.
Okay. But if the medical records say a 0.089, that's not necessarily 0.089 as a whole blood.
That's correct.
Correct. Okay. However, if someone is unconscious and not responsive for 6 hours before that test is done, 6 hours previously, whatever that number is, it would have been much higher, correct?
It's possible. It's hard to tell if that person was functioning normally because of the injury, whether they were pumping blood through their liver in a normal fashion. That's part of the problem. And what we normally would do if that person died and came to us, we would measure the blood alcohol and the vitreous alcohol, which is in the eye fluid. And we could compare the two and get a better idea of what happened, because the vitreous lags behind the blood for about an hour. So we would compare the two and say, the blood is considered the less reliable one of the two.
Okay, interesting. But there's no possible way for it to have been lower 6 hours previously, even if the body wasn't metastasizing that alcohol, correct?
It would be unlikely.
Okay. And you would agree with me that drugs such as cocaine and marijuana and alcohol can slow someone's reaction time.
Yes.
Okay. And you testified that Mr. Fernandez had a brain tumor, is that correct?
Yes.
Okay. Was this a significant size brain tumor?
I don't think it was large because they didn't see it on their initial scans of the injury. And as I recall, and I didn't have time to look at all these records because I wasn't notified, but he had other metastases as well.
Okay, throughout his body.
Yes.
Okay. But a brain tumor can also cause a slower reaction time and slower brain function, correct?
Yes.
Okay. You talked about how being T-boned, that there's nothing between the body and the door of the vehicle. If there was an airbag in that door, that would be something that would have protected, correct?
Yeah, that would help for sure. That's why the airbags have been installed in vehicles now, is to try to cushion the effects. The newest ones that they're going to put in are to the legs and the feet, because a lot of people's legs and feet get injured from that front crash.
Right.
So they've used the injuries that we find and how they occur to try to make the vehicles safer by putting in airbags. So an airbag would be somewhat protective.
Okay. It could also affect someone's injuries whether or not they're wearing a seatbelt, correct?
Correct.
And if someone has a seatbelt buckled, but it doesn't have them over their body, it doesn't help them.
No, it does not.
You, excuse me. I'm probably gonna mess up this word, but the gas chromatograph. Say that one more time.
Gas chromatograph.
Okay, is that something that is also done in an autopsy?
Yes,
Okay, and both of those additional testings that you talked about with the state, those are done in an autopsy, correct?
yes,
Okay, but an autopsy was not performed.
that's correct.
Okay. Pass the witness.
Nothing further from the state, Your Honor. This witness is excused.
Excuse from the defense as well.
Right,
Thank
the
you.
rule has been invoked. You're not allowed to discuss your testimony with anyone during the pendency of this case. All right, thank you.
Thank you.
All right,
Happy
call your,
fiesta if y'all get to go.
all right, call your next witness.
Judge, the state will call Miss Adelina Morales.
All right, if you'll take a seat here for me, please.
Judge, can I provide the witness with some tissue paper?
Yes. All right, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand. If you could state your name for the record for me, please.
Adelina Morales.
All right, thank you. All right, state, you may proceed.
Thank you, Judge. Adelina, what is your relation to Mr. Jose Luis Fernandez?
We weren't married, but we were together for 23 years.
Okay. Were you with him that night on October 13th, 2023?
Yes,
Were you there that night when the crash happened?
yes.
Let's talk about Jose. Were you aware that he was using cocaine, alcohol, and marijuana?
Yes,
Would you define him as a problem user?
no,
Did he have an addiction?
no.
How much would you say that Jose liked to drink?
I had like a 6-pack. Come home from work,
Okay,
drink himself a beer.
okay. And 6-pack on the weekends? Okay. Let's talk about the accident. You were there that night, right?
Yes.
Had Jose been drinking that night?
Um, he had said he just started.
Okay. Was he drinking in the vehicle?
I don't remember if he opened the can or not. I don't remember.
Okay. Where were y'all coming from?
He had picked me up from work. I went to the house to drop all my things.
What was in the vehicle with you?
2 of my friends,
Okay. So how many people in the car?
4.
Okay. How was Jose driving that night?
He's a good driver.
Was he swerving or weaving?
No.
Was he stopping at the stop signs?
Yes.
Stopping at red lights?
Yes.
Nothing that would make you feel worried about your safety or your son's safety?
No.
Let's talk about the accident. What do you remember from when your car pulled up? Jose was driving at the corner of 5 Palms and Middle.
Um, what I remember is taking the green light and that was it. I blacked out.
When did you come to?
A little bit later when the airbag was on my face.
Okay. How did Jose look when you came to?
He was slouched over. He was slouched over and he was just moaning.
I'll show you what's going to stay with you. 38. Is that y'all's car? Jose-
Yes, it is.
Was Jose driving this car?
Yes.
This is gonna be rough. But what injury did you observe on Jose?
I really didn't notice. I saw some blood from this side, but I didn't really notice anything else. I was trying to get my other sons out of the car,
Okay.
but I know he had some blood on this side.
Okay. Did y'all have to go to the hospital that evening?
Yes.
And this was yourself and your sons?
Yeah, they made sure we all went together.
Did y'all ever talk to a detective, Brad Armstrong, while you were there?
At the hospital?
No, while you were at the scene.
Oh, I don't remember.
Okay.
I don't think we did.
Let's talk about the hospital. Was Jose getting better?
Judge, I'm objective
No.
reading and speculation.
All right, sustained as to leading.
To your knowledge, what was Jose's prognosis?
He was never gonna wake up again.
Did y'all discuss end of life care?
Me and my sons did.
Did y'all make the choice to withdraw medical care from Jose?
Yes, we did.
Why?
Because they didn't want their dad like that.
Judge will pass the witness.
Defense.
Thank you, Judge. Morales? Ms. Morales, my name is Audrey, and I'm gonna be asking you a few questions, okay?
Okay.
I want to start by apologizing for your loss. A few questions. You stated to the state, you would have a 6-pack, and you said after work? And so that would be Monday through Friday?
Almost, yeah.
And so that night, when y'all got in the car, had he had his 6-pack?
It was at home. He had just took one with him.
Okay. So he had a 6-pack and then he took one for the road.
Yeah.
And then, you testified too that you weren't worried about safety. You and your sons being in the car. Were you concerned about him drinking that alcohol and then getting behind the wheel?
No,
Why not?
because he was such a good driver. I had no problems.
Even with the 6-pack of alcohol in the system?
No,
Okay. And was that because he would used to driving drunk?
I don't think he would be driving drunk because he would drink at home.
But not this night. This night he chose to get behind the wheel.
Yeah, with one beer.
Okay.
But other than that, I don't know if he drank or he said he just bought it. So I don't know.
Okay. But earlier testified he finished a 6-pack and then took one for the road.
No, it was a six pack and he took one from that six pack. The rest of it was at home.
Okay. And are you aware that when they did toxicology at the hospital, he had cocaine and marijuana in his system?
He probably did
Okay. And when you say he probably did, why is that?
because that was his thing.
Cocaine and marijuana were his thing?
Yes, ma'am.
Okay. How often would he use cocaine and marijuana?
Marijuana was a daily thing for him.
And cocaine?
Oh, once in a while when he get a chance to.
And that day, did he get a chance to?
I don't think so. I don't know. I wasn't there with him. I was at work.
Okay. So you were unaware of what he was doing prior?
I mean, I doubt it if he did that because it was his son's birthday that day.
Judge, I'm gonna say that's speculation. I would ask the jury to disregard that statement that she doubted he did.
All right, that objection will be overruled.
Thank you, Judge. And so, Ms. Morales, the alcohol was a daily thing after work, the marijuana was a daily thing, and then the cocaine, you said, when he had the chance. You need to answer for the court report.
Yes.
And so, even with this combination, you were still not worried about getting in the vehicle with him?
No.
Are you aware that those three can cause a delayed reaction to driving and perceiving things?
Judge, I'm gonna object to that. That's speculation that they're asking for on the witness's part.
All right, that'll be overruled. If you know, you can answer.
I mean, to be honest, I never had a problem with it.
You never had a problem with him driving while being under the influence of those three things?
He's always good. He's been a good driver. I no problem.
Okay.
And that's something that he did before me and he was a grown man, so.
Okay. And then, I want to talk about, well, let me ask, you said you had just got out of work?
Yes.
Okay. So had you been drinking that night?
No.
Okay. Just the driver?
Yes.
Do you recall at the scene after the accident that you yelled at Simon, Mr. Garza, that he ran the red light?
Yes.
Okay. And do you recall that, or let me ask this question. Did someone from your vehicle try to run from the crash after you got into the accident?
Judge, I'm object to that. That's irrelevant.
Overruled.
You can answer me.
No.
And are you aware that there were officers and a witness who stated that someone tried to run from the vehicle?
Objection, Judge, hearsay.
Sustained.
No, nobody did. I had two of my sons and a gentleman came and he's helping them out of the car and went to go lay them down on the concrete on the sidewalk.
Okay, so no one tried to run from your
No.
vehicle? One second. Defense passed the witness, Judge.
State.
No questions, Judge.
All right, is this witness excused or subject for recall?
She's excused by the state.
Excused by defense as well.
All right, the rule has been invoked. You're not allowed to discuss your testimony with anyone while this trial is taking place. Do you understand?
Yes, ma'am.
All right, you can step down.
Right.
All All right, everyone, call your next witness, State.
Judge, state rests.
All right, ladies and gentlemen, I'm going to give you a 5-minute break, then I'll call you back for further testimony. Everyone, please rise. All right, everyone, please be seated. All right, defense.
Yes, Judge, at this point, the defense would move for a directed verdict. There has been zero evidence discussing whether or not the speed was reasonable or prudent under the circumstances existing, what even driving without a proper lookout is. There has been very little to no testimony about cause of death. The only thing I think we have is that he was just disregarding a traffic signal.
And Judge, if I may respond?
Just one moment.
Of course, at your leisure.
All right, we'll take these one at a time. So with regards to cause of death, the defense is saying there is little or any evidence about cause of death. Would you like to address that?
And Judge, even if there is little, all we need is a scintilla in order to survive a directed verdict. And here we've already heard from not one, but two doctors who say that the injuries caused him to be in the hospital. And because of the causation of the crash beginning it, and then the family deciding that they have to withdraw care in it, there is but for causation of, they would not have had to make that decision, but for the defendant's actions.
All right, then the address. I'm sorry, is there anything else?
I just want to continue on. And also the cause of death per the medical examiner was blunt force trauma, which we have testimony right now, I'm sorry, in the past, that said that it was consistent with a vehicle collision.
All right, now let's move on to the defense argument with regards to speeding.
Judge, we've already had, so this goes towards the recklessness elements here, and we've already had testimony that the defendant was speeding. Detective Armstrong stated that the speed was 60 to 62, and the speed limit of that roadway was 45 miles an hour. That's clearly speeding.
All right, and then the defense has stated that there is evidence of disregarding a traffic signal. Is that correct?
Actually, I'm sorry, Judge. No, there's conflicting testimony on whether or not a traffic signal was disregarded or not. And I also have responding arguments to what we've talked about before, if you want that.
All right, the defense says that there's conflicting testimony with regards to disregard of a traffic signal. State, did you want to address that?
And Judge, I would just point to state exhibit number 2, and also even though there's even though there is conflicting evidence, there is still evidence, and all that is required by the state is to show a scintilla of evidence. Anything regarding conflicting evidence would have to be determined by the fact finder, which would be the jury. So even if there is conflicting evidence, there is still evidence, which would be a scintilla of evidence. So we would survive a directed verdict on that.
All right. And defense, it's your motion, so I'll give you a final argument.
Yes, Judge. As far as the state saying there's evidence that the defendant was going over the speed limit, there has been zero evidence or testimony that this was not reasonable or prudent under the circumstances then existing, which is the exact language that's in their indictment. Again, no one has addressed the fact that there is no evidence about what even keeping a proper lookout is. There has been no evidence of that.
All right, so state what evidence has been presented.
Judge.
And I'm going based on the indictment that he was driving a motor vehicle at a speed that was not reasonable or prudent under the circumstances then existing.
And Judge, that would be through the testimony of the officer and also through state exhibit number 2 and 1, which would show that he was driving much faster than the other vehicles that were on the roadway. And again, we only require a scintilla of evidence to survive this. And
And
further, hold on.
I'm sorry, I thought you were done.
No. So, and further, Judge, the state is allowed in the indictment to indict in the conjunctive, but proceed in the disjunctive. So even though there is an and here, we have multiple manners and means throughout. The jury needs only to agree on one or the other in order to come back with a conviction. So Judge, all we have to do is show a scintilla of evidence on one of these manners and means to show that we have given a scintilla of proof. And Judge, we would ask that.
I mean, I understand that, but I'm taking it one by one. Because if the court were to rule in the state's favor, then the question becomes, was there any evidence presented on specific points that are in the indictment? So yes, you can proceed the way you're proceeding, but each one of these allegations that are in your indictment, if you're saying we don't have any proof that the defendant was driving a motor vehicle at a speed that was not reasonable or prudent, that's what I'm on right now. I do understand that that may not mean that the proper lookout that you've presented a scintilla evidence of that. I'm taking the indictment the way the defense is proceeding and asking for their directed verdict. So
And Judge,
was there any evidence that was submitted that the defendant was driving a motor vehicle at a speed that was not reasonable or prudent under the circumstances then existing?
Yes, Judge, I believe there was. In state exhibit number 2, there were other vehicles that were driving along, and they were all being left in the dust by Unit 1, by Simon Garza's vehicle. And Judge, I believe in the transportation code, there is a presumption that if someone is driving over 10 miles an hour above the speed limit, that is presumed unreasonable. I could be wrong on that. But Judge, because of the, hold on, let me finish, please. Because the defendant has been proven to be driving at a speed 17 miles an hour over the speed limit and was going much faster to all the other vehicles that were on in state exhibit number 2. And also, yeah, also from the ACM module, there was testimony regarding from the ACM module regarding that this was a speed that was taken and maintained by Simon Garza all the way up until the very end. And further, there was no testimony about any kind of evasive action or anything in regards to Simon Garza's part before the crash. And also in regards to keeping a proper lookout, that can be inferred from the evidence that we've given, that we can see that we can see the actions of Simon Garza's vehicle. We have photos that show the markings. We also have the statements from the defendant, saying that I was aware of the lights. I was aware that they were red and that they had the green. That shows that he was keeping a proper lookout. He was aware of what was happening around him. He was not intoxicated, he was not high, and he was not messing with his phone or distracted by someone else in the vehicle. He is so aware and so keeping a lookout that he was able to tell what the light was, not only for him, but for the car that he crashed into. And the AC and the speed limit on the ACM was 17 miles in excess of the posted speed limit. Judge, I believe we've shown a scintilla of evidence to each and every one of these manners and means in the indictment, and we respectfully request that you deny the defense's motion for a directed verdict.
May I respond, Judge?
Yes.
Judge, state is relying and describing things that are not in evidence. The ACM was not admitted. There has been zero testimony of 17 miles over the speed limit. The testimony was that the defendant was going 60 in a 45, which is 15 miles over, but there's been zero testimony that that was not reasonable or prudent under the circumstances then existing. In fact, there's been no testimony about what the existing circumstances even were. The excuse me, the state is talking about how there was testimony about how Simon was traveling faster than the other vehicles. However, that actually was objected to and sustained as speculation. That testimony was not admitted. It is still speculation for the state to say that he was left in the dust was the exact words. These are facts not in evidence. These are not things that go towards proving their indictment. And there is absolutely no presumption that any certain level of speed over the speed limit is presumed to be reckless. And then additionally, the state is talking about the causation and the doctors testifying as far as the cause of death. However, no autopsy was done.
All right, and then here's the other question for the court. The other question is in regards to mens rea. So where is the gross deviation with regard to recklessness?
Judge, I believe that we've shown the gross deviation from care, one, by speeding, and also two, by disregarding a red light for more than 5 or 6 seconds, and also failing to slow down at a yellow light, which is his duty under the Transportation Code, and that has also been put in the testimony. So he maintained a speed that was over the speed limit when he not only had a yellow indicating he had to slow down, but a red, which meant he needed to stop.
But failing to slow down at a yellow light, is that the exercise that an ordinary person takes with a yellow light? They slow down?
Judge, we need only to show a scintilla of evidence in order to have it before the jury. And I would argue that the evidence that we have here in regards to mens rea, we have shown through the evidence, through the surveillance video, but also through the defendant's own words that he was aware of what he was doing, and what he was doing was in gross deviation to the standard, which was driving the speed limit, slowing down for a yellow, and stopping at a red light. And all of these reckless factors caused the death of an individual.
And Judge, I also disagree that there's actually been proof of what color Simon's light was. There's been testimony that the opposite light was red. There's been testimony that there has been lights, the 2 different lights were red at the same time. There has been an assumption of what color Simon's light was, but there hasn't actually been any actual evidence of what color that light was. And to state that they have shown the mens rea is an assumption. There's been no evidence of what my client's thought was. That no one asked him why he ran the red light. Every single officer said no, they didn't ask him why he ran the red light. There has been no evidence of what the reason was or what was going on, if he ran it on purpose, if he saw it and disregarded it. There has been zero testimony about any of that.
All right, and what I can tell both parties is this. I understand the law about scintilla, right? But on appellate issues, what the appellate court does look at is sufficient. Was this sufficient? Is there reasonable doubt in this case? And I'm looking at everything in its totality. The court understands that defense, you have a witness that is an officer who is not present.
We have been returned a phone call from the number that we were given, and it appears he gave us a wrong number, Judge.
All right, so this is, and you have, if the court were to rule against you, you have 2 witnesses?
Correct.
For tomorrow?
One being that officer and then another witness, yes.
All right. So is there any objections to my asking the court? Now, mind you, I have made a decision on how I'll rule, and I'm going to give both of y'all sufficient time to continue to argue your points with regards to a directed verdict, because I want each party to have a chance to make your arguments. But I want to release the jurors, but just let them know that they may have to stay late tomorrow. All right, any objections to the court going to the back to release the jurors?
Not at all, Judge.
All right, and then defense, any objection?
Oh, no, Judge, I said that, I'm sorry.
No problem. And then just give me a moment and I'll let you all gather your thoughts. And I'm going to go in the back and speak with them just briefly.
Thank you, Judge.
All right, so the jurors are gonna be back tomorrow at 10.
Come on.
And
Fine.
Three,
you all can make your
five,
argument
third.
from a seated position. I find that's better when you can look over things. So,
Sitting all day, I like to stand.
Any specific page?
so you all can make your arguments, and I'm here to hear whatever argument you want to make.
You want? the state to go-
Who's,
Judge, it's the defense's motion. They have the burden.
no, I mean, have you finished with your argument?
Not yet, Judge.
All right, do you have anything else to add, State?
We're scanning a case really quick, Judge, if we could just have one more moment.
Okay, I'll give you all a moment
Sorry.
to
Thank you.
scan your case, and then whatever case you're going to use, if you want to email it to the clerk so they can print out a copy for the defense.
Of course. I can print it up right now, Judge.
No, you read.
All right, let me know when y'all are ready.
Did you get my email, Judge?
Yes, I did. Yeah. And I would like these questions asked. Number one, is there any argument? Oh, y'all can remain seated.
Thank you, Judge.
Sure. Is there any argument from the defense that your client's action caused the death of the complainant? Are you saying he did not cause the death of the complainant?
I don't think that that's been proven.
All right. And when you say you don't think that's been proven, why do you say that?
Because there has not been concrete testimony. There has not been enough testimony to say that he ran the red light. There has been a statement from
No. I'm not talking about whether he ran the red light or not. I'm taking things step by step. So for a manslaughter, you have to have someone who died.
Correct.
So whether your client ran the red light or not, are you going to argue that he did not cause the death of the complainant? Now, there are other issues in the
Yes.
indictment, but I'm just going step by step because I want to see where everybody's argument is. So I think both parties can agree that the complainant is deceased, or is anyone stating that the person named in the indictment is not deceased?
No, we will agree he's deceased.
All right, so are you going to argue that his death is not the result of your client's actions?
Yes.
Okay. So let's start with that point. So you're saying your client did not cause the complainant's death?
Correct.
All right. And so what evidence or lack of evidence are you saying is not present?
Well, Judge, I think there was no autopsy, so the cause of death is disputed. There were several factors that contributed to his death. In fact, there's testimony that the renal carcinoma contributed to his death. There is several factors in the automobile accident in itself on whether or not my client caused the accident or not. The intoxication of the driver, the deceased driver, there's the question on whether or not anybody's light was red or green. All of these things are in question, Judge, and all of that all adds up to causation. If my client didn't cause the accident, then he didn't cause the death.
Okay. All right, state.
Judge, I'm gonna point to section 6.04, which is causation, conduct, and result. A person is criminally responsible if the result would not have occurred. My apologies, Cindy, I'm so sorry. A person is criminally responsible if the result would not have occurred but for his conduct, operating either alone or concurrently with another cause, unless the concurrent cause was clearly sufficient to produce the result and the conduct of the actor clearly insufficient. Here, Judge, the end result was the death of Jose Luis Fernandez. The beginning of that whole transaction was the crash. So the crash led to Jose Fernandez being unresponsive and sent to the hospital. And there is testimony to this fact. Jose Fernandez being at the hospital then led to testimony that he was not getting better. He was not going to be unresponsive. And the ME who testified today said that his injuries were non-recoverable. He was not going to get better. And then, but for that, and even on the cause of death, it shows blunt force injuries. The other significant conditions being renal carcinoma. It does not have the cancer as the main cause of death. The main cause of death were the injuries to his brain, the bleeding to his brain, which would not have been caused but for the crash, which was caused by Simon Garza running through the red light. And because of that, the family had to make the decision to withdraw there. The end would not have come but for the crash. The renal carcinoma was not enough to kill him. That has already been testified to. It was only found later. The cocaine, the alcohol, no other intervening fact can come in and cause the death of Jose Luis Fernandez on its own. This is very much a but-for causation. He would not have died but for Simon Garza's actions.
And I mean, I think the state is assuming facts not in evidence that there has been no proof of what color anyone's light was and whether or not he caused the accident. And I also think that the state has misstated the burden as the scintilla, when the burden is whether or not a reasonable and prudent juror would have enough to find the defendant guilty beyond a reasonable doubt. And I don't think they've met that burden. And I also don't think that they have proven anything on mens rea, and Audrey is going to take over on that.
You ready for that argument?
Yes.
Thank you. Thank you, Your Honor. First of all, Judge, if you look under the mens rea reckless requires actual awareness of the risk, conscious disregard that risk, and the risk has to, it's substantial and unjustifiable. Then it goes on to state that it's a gross deviation of the standard of care. Here, you can't consciously disregard a risk you're trying to avoid. Simon hit the brakes. He tried his best to avoid that risk. This was a moment. It was a mistake. It's not a criminal mindset. It's a moment, not a mindset, which is what's needed here under reckless. At most, it's negligence, but not recklessness. Also, for actual aware of a risk, you're trying to convert what he should have known into he definitely knew that this would happen. And that's just not here. We don't know if that light was red. We don't know if it was about to change from yellow to red, because if it was about to change from yellow to red, again, he did not know of that risk that would have happened by running that. Unfortunately, this is something that the ordinary person does every day, Judge. It's not an unjustifiable, it's not a gross deviation from the standard of care. And if it was, then every single person would not have speeding tickets. They would have attempted manslaughter, or they would be charged with reckless. Courts would be filled with, in misdemeanor courts, with reckless driving. Instead, they're in traffic court with speeding tickets, Judge. Yeah, and none of the officers that testified asked him why he ran that light or what happened to cause him run that light. And so there, right now, as it stands, there's no proof that he disregarded that light. There's no proof of the color of the light. We have to, again, show he knew of a serious risk. He chose to ignore that, and that here is just not the case. There's no evidence of that. Again, Judge, he perceived, you have to perceive the light as red in time. There's no conscious disregard to avoid that light because we don't know the color of it. And then it's a mistake. It's an accident. It's a moment in time. This has nothing to do with his mindset. He did not get on that roadway aware of the risk. Oh, I could kill someone and I'm going to disregard that risk. I'm going to speed. I'm going to run this light anyway. That's just not what we have here, Judge. What happened here was an accident. And we have seen no evidence to prove otherwise. We have seen no evidence that Simon was racing, no evidence that he even ran that light, Judge. So for that, the state has not met their burden of proving that mens rea of recklessness for this manslaughter charge.
All right. Any further arguments from the state?
Yes, Judge, in rebuttal to the defense's argument, the reason that there are no manslaughter charges for every single person who runs a red light is because not every person who runs a red light kills someone. There is a distinction there, which I think that they're failing to draw. Further, Judge, in regards to recklessness, it is conscious disregard of foreseeable risk. We have evidence from the defendant's own mouth that he knew the risk, that he knew that the light was red, that he knew he was driving at 60 miles an hour. He was not high, he was not drunk, he was not distracted by the radio, he was not distracted by another person. And these are all questions that were asked of him on the videos that are in evidence in front of the jury.
But didn't he say in the video, and if I'm correct, please correct me, wasn't there testimony or either in the video where the defendant was saying that someone told him that he ran?
That was in, so Judge, I think that goes towards this interview of the defendant where he makes it admissions was almost immediately after the accident. And Judge, what you're referring to is Armstrong's video, which is also evidence, which happened 40 minutes afterwards. More enough time for the defendant to see, this is probably not going to go bad for me. I better very, very coincidentally start forgetting. No, I'm in the middle of argument, man.
No, so here's the thing, everybody. I'm going to listen to argument to both sides. We can stay here as long as y'all want. I'm going to give everyone a chance to argue. The people who will have final argument will be the defense because their motion. I just want to make sure that everyone has a chance to put on the record what you all want to put on the record.
No, I'm just.
Judge,
Yes.
There is evidence. There is evidence on the record, and it has already been played in trial that shows the admission of the defendant and then his inconsistent statement afterwards. Now, that will be up to a finder of fact to decide whether they find it credible or not credible. But it is a scintilla of evidence that he consciously disregarded. He was aware of a foreseeable risk, namely driving through a red light
At a speed in excess.
at a speed that is in excess
Of the
of the
posted speed
legal speed limit. That is the maximum legal speed limit that is allowed. Anything over that is an illegal.
Sorry, that was a medical thing I had to take care of. But yeah,
Okay.
yes.
Okay, thank you. Judge, because of that, because we have the defendant's own statements. And Judge, further, recklessness requires the defendant need not be aware of the specific risk of another's death, just the result.
Speeding.
It is completely reasonable that driving 60 miles an hour in excess of the legal speed limit through a red light where other vehicles have the right of way because they have a green light puts the people in that intersection at a risk of collision at 60 miles an hour, which would cause a significant amount of damage. And we have that damage in evidence.
Yes, Your Honor. First of all, I would like to say misjudging a light or your speed is not a conscious disregard of the risk that someone can die. Because if, like I said, if that was the case, we would have people here every day with attempted manslaughter. And to say the charge changed because somebody died, what was the plan to charge him with before somebody died? Because that fact should not change it. It should not change what's required of the reckless mens rea, because that's what we're talking about. And again, recklessness requires aware of the risk, consciously to disregard that risk, and the risk has to be so substantial and unjustifiable that it constitutes a gross deviation from the standard of care of an ordinary person. Again, unfortunately, people speed. He tried to brake, and again, there's no evidence that the deceased driver's light was green. There's no evidence that his light was red. The officer even testified it's possible that his light was green. It's possible that his light was red, but we don't know for sure. And if we don't know that, we can't say that his actions constitute that gross disregard of what's required of him. And then again, there's no testimony from the scene that Simon knew his speed. In fact, the detective himself said we didn't know he was speeding till a few days later. So a few weeks later, when he chose to file the case in November. And this accident happened October 13th. And then the deceased driver's wife, Miss Morales, she testified, yeah, I yelled at him, but he ran the red light. Yeah, and you get different input from Simon because he truly does not know what happened. We saw his slow response time, which the detective testified can happen from someone who is in a car accident. So the fact that he's getting his impression from a woman who's yelling at him, it's a heightened situation. All of this does not amount to someone who took a conscious disregard of that risk. And then he has to be actually aware, oh, I'm driving fast. I may run this light and that can kill someone. That's just not there, Judge. And there's no proof of it in evidence either of that he knew his speed or that he ran a red light.
All right.
And I'm sorry, can I take over for a minute, Judge? He does say, I think my light was
Judge,
red.
I think local rules require that only one counsel take the argument at a time.
Oh, you all can argue, both sides can argue, and I'll allow each person to argue.
Very well, Judge.
I think both have already. Anyways, so he says, I think my light was red, but later says, I don't know. She told me the light was red. And then Ms. Morales also testified, yes, I was yelling at him that his light was red. Simon says he doesn't know. He also says that someone else told him his light was green. And that is admitted in the video in evidence. And additionally, state is misstating the burden by stating they have a scintilla of evidence when the burden for a directed verdict is enough evidence where a reasonable and prudent juror could find someone guilty beyond a reasonable doubt.
All right.
And Judge, I would like to.
Statement of burdens because it's viewing it most favorable.
Hold on, I can check that. So Judge, first, we would argue that anything over the posted speed limit is an illegal speed and would be a reckless act in conscious disregard of a foreseeable risk. Further, Judge,
So if the
in regard to
let's just say if so you're saying that if the speed limit is 30 miles per hour, if somebody is going 35 miles per hour, then that's reckless?
Judge, the speed limits are posted for a reason. It would be an illegal speed.
No, I mean, I understand what you're saying. If the speed limit is 30 and you go over 30 miles per hour, then you're violating the law that says the speed limit is 30. But I'm trying to get into reckless behavior.
Of course, Judge. In that case, I would like to point to the case from for the Court of Criminal Appeals, 4th District, Seton v. State. The citation to that will be 385 Southwest 3rd, 85. Now, I don't know, I'm just reading off here. I think I emailed it to you. And Judge, in that case, the 4th Court of Appeals goes over a very similar case where an officer was driving 99 miles an hour through a red light without his lights or sirens on and caused the death of a person. The court found that speed plus running through a red light, the evidence was sufficient from the record that those two elements taken together were enough for the jury to come back with proof beyond a reasonable doubt of manslaughter. This case is very, very similar to the case that we already have here and it is binding precedent as we are in the Fourth Court of Appeals District. Judge, this has already been ruled on by the Fourth Court of Appeals that this was sufficient, that these actions are reckless. And Judge, we would just argue precedent that these kind of issues have already been ruled on by the appellate courts, and they have found the evidence to be sufficient in the improving up the charge of manslaughter.
Your Honor, and I would like to draw the distinction that in that case, they said his failure to use his police cruiser's emergency lights and siren while driving at least 99 per hour through a red light intersection where police were dealing with a prior accident of striking another car, and they hadn't yet cleared that accident. So there, Judge, you can argue that you are aware of your risk. That's why police officers are often trained that when you're driving to an emergency, you have your lights and sirens for this very fact of avoiding car accidents. Here, it's entirely different. Simon hadn't had that training. There's no lights and sirens on his car. There's no proof that he was speeding, and he also wasn't going 99 miles per hour, because in that case, that officer was speeding to get to a scene. Here, there's no proof that he was even speeding. There's Judge.
You can finish and then I'll let this, then I'll let this
No,
go.
you're good. Your Honor, so I think these two cases are very much different, in that this officer as well knew that the roadway would be crowded with other vehicles because there was already something going on the scene. In this case, and 99 is not 60. Thank you, Judge.
Great, thank you.
Judge, any speed above the posted limit has the potential for being a substantial and an unjustifiable risk considering the surrounding circumstances. Here we have Simon, and we had testimony from Detective Armstrong about his ACM control model that he was going 60 miles in a 45, 15 miles per hour in excess of that speed limit. There was also video admitted that showed Simon saying he was not on his phone. He did not receive a call. Testimony regarding officer didn't observe any distractions of Simon, which arguably, if he's just behind the wheel and going in excess of the speed limit, there's nothing else to distract him. So there is recklessness there because he's aware every time I get behind the wheel, I could get in a car accident just in and of itself because driving is inherently dangerous behavior. It's an action that's inherently dangerous on the roads. Okay, regarding that. So the fact that he's driving and we can see in the surveillance that there may be other vehicles around that are changing their behavior, and Simon's throttle maintained consistent, which there was testimony of that based on his ACM module, that he was aware of a substantial and unjustifiable risk. Perhaps the jury can infer that he thought he could make it through a yellow or red, because defense is saying we don't know the color of the light, but a reasonable juror could find based on the evidence that he had a light that was not green, and he still chose to maintain the speed on the throttle until about 1.5 seconds before the impact, and there was testimony based on that. So we do believe that there is a scintilla of evidence shown regarding this to survive the directed verdict, and even then the burden of proof. A motion for directed verdict is proper when viewing all of the evidence, not cherry picking evidence, in light most favorable to the state after it rests that no rational trier of fact could find the disputed element of the crime beyond a reasonable doubt. And Judge, the state's opinion is that a reasonable juror could find beyond a reasonable doubt this is the case.
In view most favorable to the state.
All right. And you'll have final?
Yes, Judge, and the last thing the state said is the actual burden. They continue to say scintilla, and that is not the burden that is needed for a directed verdict. It is whether or not a reasonable juror could find beyond a reasonable doubt the evidence sufficient. The state wants you to believe that if there was testimony that Simon was not looking at his phone, he was not intoxicated, and there was no distraction, so that proves that he was aware of how fast he was going. It absolutely does not prove that he's aware of anything. No one asked him if he knew how fast he was going. Officers regularly ask that of people when they pulled them over. Do you know how fast you're going? No one asked Simon that. There's been no evidence that anyone asked him how fast he was going. No one asked him if he knew whether or not he ran a red light, or I'm sorry, why he ran the red light. There has been zero evidence that he was aware and had a conscious disregard of the risks. And that is the mens rea needed for recklessness to prove that.
And Judge, the defense's definition of a directed verdict is incomplete. It is also viewing all of the evidence in the light most favorable to the state. And Judge, we would argue that we have shown more than scintilla here, and all the evidence in being viewed in the light most favorable to our case shows that he was aware of what he was doing, that he was aware of what was happening, he was aware of the circumstances around him, and he proceeded forward anyway.
Okay.
Your Honor, and if I may, the state keeps arguing it's reckless as opposed to his speed. Well, the speed factor that's listed in the indictment is driving a motor vehicle at a speed that was not reasonable or prudent under the circumstances then existing. And no one has testified about any existing roadway conditions. And if you look at the instructions for police reporting crashes, that exact phrase is in there, and it follows up with including pedestrians, weather, or roadway conditions. We have seen on body cam, and on the officer's diagram, it was a straight roadway. There was no pedestrians, and the weather was clear, Judge. And so them trying to say he was reckless because of his speed, well, the speed definition, maybe example that they're using here fits this reporting crashes code for the officers, and that specifically lists roadway conditions, weather, and pedestrians. And we have not seen any of that, Judge. From what we have seen, this road was pretty empty. There was a few cars, but that's it. And again, Your Honor, I would argue that we have not seen any proof that Simon ran that red light, that he was aware of that, or that he was aware of the risk, and that he was aware of his speed at that time, because no one asked him these questions, Your Honor.
Anything else?
Regarding conditions, Judge, the videos are admitted, and in the videos and body worn camera, you can see it's not raining. The roads are not wet because of weather conditions. We can see the oil slicks in some of the photos, and you can see the glisten of it not mixed with anything else because the road is dry. So to say that there's been zero evidence of conditions would be incorrect, because the body worn camera and photos have been admitted, and that can be deduced based on that evidence, although not explicitly as what the conditions were. It can be inferred and deduced based on that evidence.
Judge, I'm just going to reiterate all of our arguments that there has not been enough evidence for a reasonable jury to find the defendant guilty beyond a reasonable doubt, and they have not proven their mens rea or all of the elements in the indictment. We ask for the directed verdict.
And Judge, we would ask that any of the evidence be seen as totality and in a light favorable to the state.
That is the law, but I still don't think they've met their burden, even taking that into consideration.
Okay, all right. I'll help you all come back tomorrow. The jury's going to be here at 10. So I do have cases at 9. So if y'all can be about here about 9:15, 9:20, and I'll give you my ruling.
Thank you, Judge.
All right, thank you, guys. All right, if you can make sure before you leave, give your mics to the court reporter, and also go over